Hi, hello everyone, and welcome to your first lesson in this legal English course. Welcome here. And the first lesson is going to be about legal drafting style. So let's go, let's start. So, what exactly are you going to learn today? You're going to learn the core principles of clear, precise legal drafting in English. You will learn 12 key vocabulary words with phonetics. As for grammar, you're going to learn what is nominalization, passive voice, and the difference between active and passive choice in legal drafting. And of course, how to rewrite poorly drafted clauses into professional legal English. І хвилиночка на правах реклами, так би мовити. Ви можете знайти саме цей воркшіт та набагато більше освітнього корисного контенту в нашому телеграм-каналі та інших соціальних мережах. Ми всюди називаємось The 13th Stance, 13-й час. І також ви можете зараз відсканувати цей QR-кодик, якщо у вас є можливість, і перейти в наш телеграм-канал. So, the first part, let's start with the video content. I'm going to go a little bit too fast in some cases. Yeah, I'm going to skim through those. But if you need, you can pause the video and read those words, read the vocabulary. Take your time, read the examples, read the explanations, definitions, read the transcription. If you have problem reading the transcription, you can Google the word and write down next to it pronunciation, and you will see tons of videos helping you with that. Or you can scroll back, rewind the video a few seconds, and listen to me pronouncing it, okay? So, the first word is plain drafting. Plain drafting. Plain drafting means writing legal documents in clear, simple, unambiguous language. So, and the example is plain drafting avoids jargon and makes contracts easier to enforce. The next one is active voice. Active voice. That's a sentence structure where the subject performs the action. The supplier shall deliver the goods. That's an example of an active voice. And passive voice, that's the opposite. That's the sentence structure where the subject receives an action. The goods shall be delivered. It uses passive voice. The next one is defined term. Defined term. Defined term means a word or phrase given a specific meaning in the definition clause. And agreement is the defined term. It refers to this specific contract. Cross-reference. Cross-reference is a reference within a document to another clause or section. So see the cross-reference to clause 5 in the payment provision. Ambiguity. Ambiguity. That's unclear or double meaning that could be interpreted in more than one way. And the next one is using here is an example. Wait, before the next one, I'm sorry. And ambiguity in a contract creates risk. Courts may interpret it against the drafter. And redundancy. Redundancy means using more words than it is necessary. Yeah? Null and void is a classic example of redundancy. Both of these words mean the same thing. They mean the same thing, the very, very same thing. Consistent. Consistent is using the same word or phrase throughout to mean the same thing. Be consistent. If you call the agreement in clause 5, do not call it the contract in clause 5. Yeah? Makes sense, makes sense. The next one is precision. Precision, the quality of being exact and accurate in language. Legal drafting demands precision. Vague language leads to disputes. And nominalisation. Nominalisation is a really interesting grammatic structure. We will discuss it today, but that's basically when we convert a verb or adjective into a noun form. So we convert action or description into the name of the process or the item. Yeah? Decide the decision. Failure, the failure. So nominalization helps us to create formal and precise drafting. Redundant pair. Redundant pair. That's two words meaning the same thing used together unnecessarily. Null and void, terms and conditions, cease and desist. They are all redundant pairs in some or another sort of way. And the next one, contra preferentum. Contra preferentum. The rule that ambiguous contract terms are interpreted against the party who drafted them. The contra preferentum rule is a strong incentive to draft clearly. And a little pro tip, in legal drafting, the choice between active and passive voice is nuanced. Use the active voice when it matters who performs the application. The supplier shall deliver. And use the passive voice when the actor is obvious or irrelevant. Notice shall be given within 14 days. Never use vague passives that hide who is responsible for an obligation. Okay? And let's go to the grammar, guys. And in grammar, we're going to talk about nominalization, active and passive choice. So the first one, nominalization, as I told you, that's when we convert verbs into nouns for formal, precise drafting. For example, fail to deliver, failure to deliver. Decide, the decision. Perform, the performance. Terminate, the termination. And then active and passive voice. Could you please look at these examples? So active voice, we use it when the obligation holder must be clear. The supplier shall deliver the goods by the delivery date. Clear? Clear. The client shall pay the fee within 30 days. Clear? Clear. And the passive voice, we use it when the actor is obvious, unknown, or irrelevant. Notice shall be given in writing. The goods are deemed delivered upon signature. This agreement is governed by English law. So, how to always put the passive voice in the correct form? I'm going to give you a little life hack, yeah? So, to put passive voice in the correct form, you do not need to learn the forms of passive voice for each tense, for each modal verb, for every possible thing when it could be used. All you need to know, you have an item on which we actually perform the action. For example, in our case, notice, or the goods, or this agreement. Then, after that, you put verb be in the correct form as it works in this tense, right? As it works in this tense. I'm sorry, I need to grab my little charger. Well, so, and then after that, you always put the verb, the action, which we actually perform, in the third form, if it's an irregular verb, or with ed ending, if that's a regular verb. So, to make it a bit easier for you, we have an item that is receiving an action, yep, plus be in correct needed form. It all depends on the tense you use. It all depends on the modal verb you use. Yep, for example, shall be. After modal verbs, we use basic forms, yeah? Shall be. Or for example, have to. Yep. And then you use the verb, the action itself, in the third form or with the ending ed if that's correct. Okay? Okay, I suppose it is a bit clear. And of course, if you need to add an actor as someone who performs an action, that's going to be by somebody. Take a second, look at these examples. I believe they're all pretty much clear. As always, if you have any questions, guys, you can actually text them in the comments and I'll make sure to get back to it and reply, okay? Then here we have some phrases to avoid and some phrases to use. So null and void. It would be better if you avoided the same words again and again. Let's use just void. Cease and desist. Cease and desist is the great noun combination, like the name of the contract, for example, cease and desist. But as verbs, you can just simply say stopped, cease, terminate. Okay? Terms and conditions. Could be. That's a great name for a contract itself. You can use just simply terms. The said agreement. This agreement. It is hereby agreed. The parties agree. I mean, you could use this, yeah? Within a reasonable time. What exactly is a reasonable time? It is a bit ambiguous, don't you think that? You need to state the exact time. For example, within 14 days, within 30 days, within 2 hours, yeah? Effect delivery. Deliver. Aforementioned. Defined term. You need to use the defined term. Yep. And then the why. The explanations you have. Why exactly do you need to use not these things, but these, okay? You can also pause the video, take your time, go through it. Yep. I suppose you won't have any questions about it. It is easy peasy. Yep. And here we have a little modal clause before and after poorly drafted and plain drafted. So, poorly drafted. It is hereby mutually agreed between the parties hereto that the said supplier shall, in a timely manner and without undue delay, proceed to effect the delivery of the goods to the aforementioned buyer at the address as specified in Schedule 1 attached hereto. By the way, as for schedule, you can read it schedule, you can read it schedule. I don't care. Both are correct. And as for plain drafted, once again, guys, we are not talking today about some extremely sophisticated, complicated, unique contracts. We're talking about plain drafts. The supplier shall deliver the goods to the buyer's address set out in Schedule 1 within 14 days of the order date. That's all. That's all. Please notice, active voice, specific time frame, defined terms, no archaic language. Legal English is full of archaic language, and we just have 17 words instead of 50. Here are some common mistakes that you need to avoid. For example, the delivery of the goods will be done by the supplier. Okay, could be possible. The supplier shall deliver the goods. If we are aiming for plain contract, for plain draft, it is better to use such sentences. Also, by the way, all this language that you're getting from today's lesson, you could actually use it not exactly to write plain drafts, but to explain to your client or to your assistant or whoever you need to explain it what exactly is written here. Because let's be honest, the legal English is full of archaic language, and clients need to understand what exactly is going on, right? Active voice and shelf obligations. Why not? The contract is null and void. The contract is void. Null and void is a redundant pair. The said agreement shall govern. We could just simply say this agreement shall govern. The said is archaic. Failing to deliver. Noun use. the failure to deliver. Failing is not exactly correct nominalization. It is a gerund. You can use gerund, but in this case, it's better to use the failure. The parties here to agree. You can just simply say the parties agree without here to. And a quick check. Pause the video. I'm giving you 20 seconds to pause the video, rewrite each phrase in plain legal English, and then we're going to check. Starting now. Giving you 20 seconds. Take your time. Take your time. And complete it all. I really hope that you pause the video and complete it all. You can just do it in your head. You do not need to write it down, or you can actually note it. And in a few seconds, we're going to check it. So let's check it out. Null and void, just simply void. Cease and desist, stop, cease, terminate. It is hereby agreed that the buyer will make payment. The buyer shall pay. Or, for example, the buyer shall remedy. It all really depends on the context. The aforementioned agreement. This agreement. The delivery of the goods shall be effected by the supplier within a reasonable time. The supplier shall deliver the goods within a certain number of days of the order date. And then you have a speaking challenge and the question for the comments. Could you please look at this text and could you reformulate it to plain English? You can write it down. You can just say it out loud. You can record yourself saying it so that you can listen to it again and check it. Yep. And as for the question for the comments, could you find a sentence from a real contract that is unclear or complex and share it below and also try rewriting it in plain English, okay? And the last part in here is workbook. I am not showing you a workbook. You can go into our Telegram and find it in there. Okay, you guys. I really hope you do. I really hope you do that because there are tons and tons of useful content. Okay? And thank you so much for clicking on this video. I was happy to see you today. Stay safe and have a great day. Bye bye.